A major legal challenge to the National Firearms Act, specifically targeting its restrictions on short-barreled rifles, is now before the Supreme Court. The case, U.S. v. Rush, is moving toward a Supreme Court conference scheduled for September 29th, and it could have serious implications for how federal firearm regulations are enforced. But there's a new twist. Congress recently passed legislation setting the tax on suppressors and short-barreled rifles at $0, which may significantly shift the course of this case. Before we get into what this means, make sure to subscribe to the channel for continued updates on this important challenge and others affecting your Second Amendment rights. Now let's talk about the Rush case and why it's so important. This case directly challenges the constitutionality of the NFA's restrictions on short-barreled rifles. Mr. Rush was charged with possessing an unregistered SBR, a charge that stems from the requirements under the NFA. In response, Mr. Rush argued that these restrictions violate the Second Amendment and that the charges should be dismissed on constitutional grounds. The case has now reached the Supreme Court, where a petition has been filed asking the court to reverse the lower court rulings and determine that the NFA's restrictions on SBRs are unconstitutional. The core question presented is this: does the Second Amendment protect the right to possess unregistered short-barreled rifles that are commonly used for lawful purposes? Adding more weight to the petition, the NRA emphasized that since the Supreme Court's Bruin decision, lower courts have struggled with the new historical test set by the court. There is now widespread disagreement over what qualifies as a bearable arm under the Second Amendment. This case, they argue, is an ideal opportunity for the Supreme Court to step in and bring clarity to the issue. But with the recent passage of the so-called Big Beautiful Bill in Congress, which includes a $0 tax on suppressors and SBRs, this case may face unexpected shifts or challenges. The legal and political landscape surrounding the NFA is rapidly changing, and this case is now caught in the middle of that transformation. One particularly significant aspect of this case is that, while it focuses on short-barreled shotguns and the arbitrary restrictions placed on such firearms, the broader goal is to prompt the Supreme Court to clarify which types of arms fall under the protection of the Second Amendment. This clarification could have far-reaching consequences, not just for this case, but for ongoing legal battles involving state-level rifle and magazine bans. The petition asserts that the Second Amendment protects all bearable arms, including short-barreled rifles, that are commonly owned for lawful purposes. It challenges the interpretation used by the Seventh Circuit, which concluded that short-barreled rifles do not qualify as arms under the Second Amendment. To counter this, the petition presents data showing there are at least 532,000 registered short-barreled rifles in the United States, a statistic used to demonstrate their widespread and lawful use. The National Rifle Association further criticized the Seventh Circuit's dismissal of this evidence, emphasizing the real-world ownership and application of these firearms. At the end of the petition, the request to the Supreme Court is clear. Grant certiorari to resolve these conflicting interpretations and provide nationwide clarity on whether short-barreled rifles qualify for Second Amendment protection. The case raises critical constitutional questions about how far government restrictions can go in regulating these types of firearms. In response, the U.S. government, represented by Solicitor General S. John Sauer, filed a notice indicating they would waive their right to respond to the petition unless the Supreme Court specifically asks them to do so. Following this notice, the Supreme Court docket shows that the case is now scheduled for conference on September 29th at the beginning of the next term. However, it's important to understand that this doesn't mean the court won't request a response before that date or seek additional information afterward. Much of this case developed before the recent passage of legislation that includes the so-called Big Beautiful Bill, which contains the Hearing Protection Act and the Short Act. One of the most important outcomes of that legislation was the reduction of the $200 NFA tax to $0 for suppressors and short-barreled rifles. While this doesn't completely eliminate the NFA's restrictions, it marks a major shift in federal policy and opens the door for further legal challenges. In light of these developments, Gun Owners of America recently filed a lawsuit in federal court in Texas. That lawsuit was brought forward in coordination with other industry organizations, including the Firearms Regulatory Accountability Coalition, FRAC, Palmetto State Armory, and Silencer Co., among others. Additional lawsuits from other groups are expected in the near future. In this Texas lawsuit, the plaintiffs argue that the NFA's registration and transfer requirements, now applying to firearms with a $0 tax, exceed Congress's enumerated powers under the Constitution. Since there is no longer a tax, they argue that Congress lacks the authority to continue regulating, registering, and tracking these firearms. The lawsuit also calls on the court to prohibit the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, and its agents from enforcing any part of the NFA that pertains to these untaxed firearms. The central argument is that the NFA's enforcement and registry systems were justified solely as tax-based regulations. Now that the tax has effectively been eliminated, those justifications, and by extension the enforcement mechanisms, no longer have a legal foundation. A new legal challenge has now been launched, focusing on the National Firearms Act, NFA, as it stands under the updated language introduced through the Big Beautiful Bill. At the same time, the Rush case remains active and is now scheduled for conference at the Supreme Court. This creates a few possible outcomes. First, the Supreme Court may request supplemental briefs or additional information to help clarify how the new language in the NFA, specifically the change to a $0 tax, affects the case and its direction moving forward. Another possibility is that the court may consider the petition moot, based on the fact that the law in question has changed. If they determine the case is no longer applicable under current law, they may send it back to the lower courts to be reevaluated in light of those legislative updates. There's also a real chance that the court could simply deny the case after the conference. If that happens, it might also include a note instructing lower courts to reconsider their rulings based on the recent revisions to the NFA. As things stand now, this is a rapidly evolving situation. The tax requirements under the NFA for short-barreled rifles and suppressors have been fundamentally altered, and that change is likely to impact numerous ongoing legal challenges. Many of the cases that were filed to contest NFA restrictions on items like stabilizing braces, suppressors, and short-barreled shotguns may now require amended arguments or fresh legal strategies to account for the updated language in federal law. In many of these cases, courts may now ask for new evaluations that take these changes into account. One of the key issues to watch is how the Rush case at the Supreme Court is impacted by these developments, and what implications that could have for similar cases, such as the Peterson suppressor challenge currently pending before the Fifth Circuit Court of Appeals. It also remains to be seen how the Trump administration will respond if the Supreme Court requests an official response to the Rush petition. If they are asked to weigh in, it's possible the administration will take a position similar to what we saw in the Peterson case. In that instance, they argued that the NFA's suppressor regulations were constitutional, but they may now also acknowledge the need for the Supreme Court to decide whether items like short-barreled shotguns, suppressors, and other regulated firearms fall under the protection of the Second Amendment. This is a critical question that has divided lower courts and could benefit from definitive guidance by the Supreme Court. So once again, this entire situation remains in flux, and it's clear that recent legislative changes under the Hearing Protection Act and Short Act, both part of the Big Beautiful Bill, will have a significant ripple effect across multiple legal battles. As always, I'll continue to monitor these developments closely and provide updates as new information becomes available. If you'd like to support the channel, one of the best ways to do that is by subscribing. Thank you all for watching, and don't forget to like, comment, and subscribe for future updates.